Now, I wanted to bring it to the the learned community, particularly the English-speaking people. The amendment made to the 19th, to the Constitution through the 19th Amendment, reducing the office of the Executive President period term from 6 years to 5 years, and there is a requirement in the set out in the Constitution, Article 82, how the Constitution can be amended, particularly the Constitution and the entrenched provisions. Any ordinary amendment to the Constitution can be adopted with two-thirds majority. However, if there is there are certain provisions in the Constitution that cannot be amended by 225. For example, Article 1, Article 2, Article 1 is the the Republic of Sri Lanka is sovereign state. Article 2 is a unitary state. Article 3, the sovereignty is in the people. Article 4, how the sovereignty is exercised, that is the legislative power through the parliament, executive power through the executive president, then the judicial power to the judiciary, and Article 4D is all three organs are required by the Constitution to protect and enhance the people's sovereignty and the people's sovereignty in the people, and to defend the fundamental rights of the citizen. Article 4E is your franchise. Article 5, it is not an entrenched provision, that is about the 24, that is the number of districts. Article 6, 7, 8, that is the national anthem, national flag and the national day. Article 9, Buddhism. Article 10, your consciousness, self-consciousness, again, Article 11, Krura Amanusika, Vadhihinsa වලින් නිදහස් කරේ. කියන්නේ ඒකත් ඇවිල්ලා entrenched provision එක. මොකක්ද ඒ කියන්නේ? ඒ කියන්නේ cruel and inhuman, freedom from cruel and inhuman and degrading treatment. And also there are two more, that is if anyone wanted, if 225 wanted to increase the term of the executive president from whatever, increase or decrease or whatever, any amendment to the term of the executive president as set out in Article 30, and also Article 62, that is the term of the parliament, if they wanted to amend it, law very specifically provides how they must, there is no option, they must come before people and get a mandate. Now, I have gone through this bill, this particular case initiated and filed with the Supreme Court yesterday. It's very clear, it's 100% accurate. I am 100% sure this bill, this particular case has been designed and this petition has been drafted by Ranil Wikremesinghe's group of lawyers. They very clearly say this particular, the decrease of the change made to the term of the executive president through the 19th Amendment to the Constitution is illegal, invalid, and it is not a valid provision of law, and it is ab initio void. That means from the very day it was enacted, it is not a piece of legislation, as it is not, this particular provision of law has not been adopted by the people at a referendum. So the role of the judiciary in this country is to defend the Constitution. This piece of legislation, the 19th Amendment, the term of the executive president has been reduced from 60 years to 5 years without obtaining a mandate from people. So therefore, Article 82 very clearly set out as to how the Constitution can be amended. Ordinary piece of legislation, there is a provision in the Article 80, once the Speaker certifies a bill, judiciary has no business. That is how they have done it. Earlier we had that opportunity. Before the independence, the Salisbury Constitution, Sri Lankan people enjoyed the judicial review. Any act passed by the parliament, people had the authority to challenge it in the court. But 78th Constitution, there is a provision. If there is an amendment made to the Constitution, unlawfully, violating the sovereignty of the people have a right to challenge it in the Supreme Court. That is what exactly done by this case. One Mr. Chaminda Dayan Lenava, he has challenged it in the Supreme Court on the basis due process has not been followed. What is the due process? Ordinary bill to amend the Constitution, two-thirds majority is required. But special amendment, that is to increase or decrees or whatever term of the office of the executive president of the parliament must obtain a mandate from the people. If that has not been obtained, the constitution very clearly says, I must read it out for you, then only you will understand. Article 82(6) says, very clearly it says, any such amendment made to the constitution shall not become law. This is how it says. In the article 82(6) says, no provision in any law shall be deemed to be amend, repeal or replace the constitution or any provision thereof, or be so interpreted, construed, unless enacted in accordance with the requirement of the preceding paragraph of this section, this article. What does it mean? Any amendment to the constitution has to be adapted through the due process as set out in Article 82. Ordinary bill, 2/3 majority. Special bill that violate any of the entrance provisions, in addition to the 2/3 majority, must obtain mandate from the people. If that has not been followed, the role of the judiciary under Article 125 is to interpret appropriately. Any such provision of law shall not be interpreted that it has been adapted following the due process as set out in Article 82. That is the challenge. That is why the people, one citizen has challenged it. This defends the constitution. This is a good development. Why? Why Nagananda prove it? Why Nagananda is behind this? Because it gives authority to the Supreme Court that exercise your judicial power purely on trust to repeal or reject and condemn any law adopted by the parliament unlawfully. I hope that you got the essence of what I explained. If you have any issue, you are welcome to put forward anything and you can question anything. I am there to answer you. But I must tell you, this is a work. This particular case has been initiated by Ranil Wikremesinghe, not anybody else. He is the one, that is why when he was, when he wanted to enter parliament through the Article 99A, which is absolutely illegal, I asked these two people, Sajid Premadasa and Andare Disanayaka, I said, raise this issue. He cannot enter the parliament through the national list, which has been enacted without following the due process as set out in Article 82. That is the very thing. I don't know whether Ranil Wikremesinghe had an opportunity to go through the other case that we filed, the Wikremesinghe Foundation, that is to declare the Article 99A invalid. So he is asking the same thing in this case, that the amendment made to Article, Article 30 of the Constitution is not valid. So therefore, I believe, my contention is that there is nothing wrong. Everything is, this petition has been designed and drafted purely in accordance with the Constitution, and the Supreme Court will defend the Constitution. I won't say what would be the judgment, but I can say there are some merits in this application. Let's wait and see. So there is nobody to be blamed. Who is to be blamed? Sajid Premadasa and Andare Disanayaka, who allowed this great Machiavellian, Ranil Wikremesinghe, to enter the parliament unlawfully. Now they have to be blamed themselves. Thank you very much.